In order for co-op and condo boards in New York to pass enforceable smoking prohibition rules as to interior apartments and not common areas, the boards need to, in the case of co-ops, amend their proprietary lease, and in the case of condos, amend their declarations bylaws. For co-ops, the board itself doesn't have the authority alone to do it. The board needs to obtain a shareholder vote or written consent, usually 2/3 of the total number of shares, in some instances 3/4, must vote or sign written consents in order to amend the proprietary lease and create a lease enforceable prohibition against smoking within apartments. In the case of condos, the boards usually need, per their bylaws, two thresholds to be met: 2/3 of the apartments and 2/3 of the total undivided interest must vote in favor of a prohibition, a smoking prohibition within apartments in order for it to be enforceable in the condo context. In both instances, co-ops and condos, the boards do not have the legal authority to restrict smoking within apartments absent obtaining those approvals of shareholders and unit owners. Boards of co-ops and condos can amend their house rules and their rules and regulations in the case of condos as to common area smoking prohibitions within the buildings and outside of the buildings. But again, within apartments, unit owners and shareholders must approve in the manner in which I just summarized.